Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. Excuse me. We have a question here from Isaac Trade 9358, who asks us, "Hey Vince, hope you're doing well." Thank you, Isaac. I hope you're doing well as well. Quick question. Why would law firms not take you as a potential client? Reason being, they believe my previous employer is shady. Other question would be, how many conversations do you usually have with your client when dealing with a misclassification case? Okay, so I think you actually asked three questions, right? The first question is, why would law firms not take you as a potential client? I actually have videos directly answering that. There's many reasons, so I would watch that video. I'm not going to recreate it here. The simple answer is you don't have a case, your case isn't worth enough, or you're too much of a pain in the ass. Those are generally the three reasons, or they didn't listen to you, right? They didn't fully understand your claim. They didn't take the time and do the right thing to like really understand your claim, right? So that is the quick and dirty answer on why they might not take your case. Now, you go on. Your next question is, reason being, they believe my previous employer is shady. So I guess you're asking, would they not take my case because these firms believe my previous employer is shady? No, that's not a thing. All employers are shady. That's how they became employers. But more importantly, think about what we're really saying here. We're saying like you're a victim of some horrible thing they did, right? Your employer did. That's what employment attorneys do. They go after bad employers. So pretty much every employer we go after, we'll put aside the joke that all employers are shady, but every employer that we go after is shady. So no, that's not a thing. And if they said that to you, and they're full of the, how we say, doo-doo, caca, like it's nonsense. That's just it. I suspect, in my personal opinion, they just didn't want to deal with you for whatever reason, or they didn't want to take the time, or whatever it is. But that's not a reason to not take a case. Now, counterpoint, what they may have meant is, hey, I don't know if we can collect on this case. They might be worried about a bankruptcy. They might think the employer is going to hide money in another country in some clever way. That could be what they mean by shady. That's the only version of shady that moves the needle for me. Is I've certainly seen employers where I was like, well, that money is going to be in Pakistan in about 30 minutes. And you got to figure out, well, can I get it before the money moves? And it's a tough calculation, right? So, you got to be aware. But realistically, the answer is, do employment attorneys pass on cases because of shady employers? No. Do they pass on cases because they worry about collecting? Because of bankruptcy or some kind of shell game with money? On rare occasions, very rare occasions, yes. Now your third question. Other question would be, how many conversations do you usually have with your client when dealing with a misclassification case? So I don't take too many misclassification cases. I prefer to engage in workplace sexual harassment, workplace discrimination, retaliation claims. That's really what we do. We do it in all 50 states. Certainly we have run misclassification cases. We even have a few right now. Probably about 5 conversations before we take a misclassification case. Most people who think they have a misclassification case don't. Most people who actually have a misclassification case are not aware of it. I don't know why. I think that we in our education system do a really bad job of teaching people their rights as employees, which is weird because our education system is largely created and tailored to forcing people into economic servitude to become employees, right? So I guess maybe it makes sense from that perspective then that they're not arming you with your rights to contend with your employer. They want you to be a good little employee instead of an empowered employee, right? But that's just my thought and worldview. You don't have to subscribe to that, certainly. You do have to subscribe to the channel because now you've watched almost 5 minutes of me. And I mean, at that point, you owe me something. Kidding. But like and subscribe. Um, so yeah, probably about 5 conversations on a misclassification case, because on a misclassification case, I'm looking for the time waster, right? There's a lot of people who come in and they'll have read some of the elements and they'll know what to say, but the things they're saying might not always be accurate. And it is not necessarily cheap to run a misclassification case. So, you want to be sure, because that can be kind of an expensive swing and a miss, right? You don't want to swing and miss ever in this industry, but especially on a case like that. So, yeah, 5 conversations, some document review, spend the time, invest the case. What is it? A stitch in time saves 9, right? Like, absolutely true. If you're not investing time in a case early on before you take it to really understand, is this a case that I want to shower money upon and just invest in, pour attorney time into, right? If it's not that case, don't take it. Because 1, you're going to have an unhappy client because the client does want you to do that. 2, if you're not going to invest in the case, time and money and talent and creativity and everything else an attorney needs to bring to bear in this field, then listen, you're not going to make money. It's not going to go as well. You're not going to maximize value. You're not going to reduce risk. It's a fool's errand, right? So invest heavily, lots of doc review, look at everything, challenge everything, kick the tires, read the book. Sometimes you hire a private eye, right? Like, you got to do what you got to do. To be clear, where that's legal and ethical, and attorneys are allowed to do things like hire private eyes. I would never do that in a jurisdiction that frowns upon that, because I like my license a great deal, and I will not be losing it anytime soon. Anyways, Isaac Trade 9358. Quick recap. Why would an employment law firm not take a case? Case doesn't make economic sense. They're not listing correctly. You're a pain in the ass. Would an employment firm not take a case because the employer is shady? Almost certainly not, unless it's a collections issue. And 3, how many conversations do you have with a potential misclassification client? And misclassification means you're not properly classified under essentially the pay laws, right? The Fair Labor Standards Act, things of that nature, to be, receiving overtime and things of that nature. As many as you can, as much time as you can invest. All the review, look at the statements, look at the pay slips, look at the policies, do some research, talk to the client, multiple touches, go through the story more than once. Go through the story out of time order to make sure the story is true, even outside of a practice narrative, right? Like, and I don't mean to sound like I'm challenging like misclassification clients. I'm sure all y'all are lovely, fantastic people who mean well and want to get your rights served and protected, right? And that makes sense. Counterpoint, you are asking a law firm to spend a lot of time and money on a case, and they need to be very careful and really check, right? Anyways, Isaac Trade 9358. I wish you great success. I hope you find the counsel you want. I hope you get the win you want. I hope you are made whole and you have everything you're looking for and all the wrongs are righted. If this video was helpful, like, subscribe, comment down below, share the channel so it will grow. Take care.